When a party to a contract promises to do a certain thing before a specified time and fails to do so before that time, the unperformed contract becomes voidable at the option of the promisee if intention of the parties was that time should be of essence of the contract. We saw yesterday what is meant by intention of the parties, how it is to be determined. Today we will see what is the meaning of the contract becoming voidable at the option of the promisee. Under the contract, certain thing was to be done by a certain time, and the party which has promised to so do the thing by the certain time has failed to do so. This section provides that the remaining contract becomes voidable at the option of the promisee. What does it mean? Becoming voidable, the contract becoming voidable at the option of the opposite party. As per the definition given in section 2 of the Contract Act, when a contract is voidable, it is enforceable at the option of the other party, but not enforceable at the option of the other party. So when we say the contract becomes voidable at the option of the promisee, it means it is only the promisee which can get it enforced in a court of law, and the party which has failed to fulfill its promise, that is the promiser, forfeits his right to get the contract enforced in a court of law. What section 55 means is that once the promiser fails to do the promised thing by the time specified, he forfeits the right to approach a court for enforcement of the contract. It is only the promisee which retains that right. Otherwise, both parties have the right. So it is the promiser who forfeits the right, which means thereafter, if the promisee also decides not to perform his part of the contract, the promiser has no way of getting it enforced because the doors of the court are closed for him. But on the other hand, the promisee has that option and he can approach the court for getting the remaining part of the contract enforced.